Ambassador, the one thing I don't really understand about your narrative is this idea that different kinds of people are picked up on the battlefield, and they might be lawful combatants or unlawful combatants or criminals or terrorists or innocent people. That idea is not unaddressed in the law. The Geneva Conventions have a tribunal process for sorting those people out. Why did we elect not to use the Article 5 tribunal process that the conventions provide?
Yeah. Well, I'll tell you, and of course I have to be careful on everything that I say, but that was a debate. There were portions of the administration that advocated for Article 5 tribunals. Then there were people who would say, well, what is an Article 5 tribunal? In other words, there is not exactly, if you canvass the globe, there is not a particular set of requirements that say this is what an Article 5 tribunal needs to look like. And there are people who would argue that in effect, while what we were doing in Bagram before we sent these people over were not called Article 5 tribunals, but there was a triage or an assessment, albeit many times in my opinion weak, that would take place. And then there's the other element where as you're debating here, do the Geneva Conventions apply in their entirety to these unlawful or enemy combatants? And if the answer is no, then that requirement may not exist. So that was effectively the debate that took place.
Hi, Ambassador. I'd like to ask questions about the two types of assurances you were speaking about that you sought from foreign countries to what you say was assuming responsibility over the citizens. Regarding responsibility to manage the threat, I think you said, why would the UK, or how would the UK accept your demands that it, as you say, manage the threat where it is based on the assessment of the threat is based on information often obtained by torture, and by accepting it, the UK would actually compromise its own values. Another issue, I work for Amnesty International, and our researchers were speaking to these two detainees in the Yemen who were there for over a year, and having come back from Guantanamo, and speaking to the authorities, they asked, why are they detained? They said, what do you have against them? We have nothing, but the US want them to remain detained. The other question is on assurances regarding humane treatment. Could you please detail what type of assurances you get, and what you do in the face of, for instance, the case of Abdallah Haji, who was returned to Tunisia from Guantanamo and was subsequently tortured by the Tunisians? Thanks.
Well, I'll try to answer all your questions, and I hope I got them all. But I think first there are a couple assumptions in your question. One, the assumption that everyone was tortured. Two, there's an assumption that what actually happened to some of these individuals was in fact torture. I won't get into these questions, but that's the assumption that you're making. But what we did in all these cases is it was not a situation where these governments, and we're using the UK as an example as opposed to giving you factual information. But what we did, all these governments came to Guantanamo and visited Guantanamo repeatedly, many times, numerous times, and spent time with their nationals. So they were able to gather their own information and assess for themselves whether these individuals in fact posed a threat. They were also able to determine for themselves whether these individuals have been abused in any way or not, as was the ICRC that came to Guantanamo. So when we were asking people to manage the threat, we purposefully described it that way because we were flexible in hearing from these governments as to what they were prepared to do. Our démarche, so to speak, was saying we would ask them that they would detain, investigate, and or prosecute as appropriate. We would also ask them to monitor. Now, from there, we would get into detailed negotiations to understand. In some cases, people were sent back and were actually detained. In some cases, people were sent back and they were not. They were monitored. In some cases, we released people saying they could go free, and they went back and they were detained. In some cases, we sent people back asking them to be detained, and they were released. So it's not a perfect situation, but what we did recognize is we tried to get enough assurances that would give us comfort in moving forward and releasing these people from our control. Now, the human rights issue is, granted, it's a challenge. It's a challenge with particular countries. I was not involved in the Tunisia case, so I can't speak to that. But in many of my negotiations, we would ask for exactly what principles of law that they would honor. We would ask them about third-party access to the detainees in order to check on their well-being and try to get those type of assurance. We didn't want to be the ones to now be on the hook of monitoring someone else's system, but we wanted to have a system that allowed for perhaps ICRC or someone else to check on it. So you can imagine that, again, there were complex issues that were involved in all of these negotiations.